8:30 a.m. start time, so we'll go ahead and commence. I'll begin with the call to order. Today is Thursday, October 24th, 2019. This is the meeting of the Board of Accountancy. It's a regularly scheduled meeting. It's taking place in Conference Room 1A of the Davy Crockett Tower at 500 James Robertson Parkway here in Nashville, Tennessee. The meeting date, time, and location have been properly noticed, and copies of the agenda were posted to the Board of Accountancy website on October 18, 2019. We do have a couple of board members calling in via phone, so we will be taking roll call votes today on items that need a vote. And Karen, I'll ask you for a roll call and to confirm a quorum.
Andy Bonner.
Aye.
Janet Booker Davis. Here. Pamela Church.
Here.
Stephen Eldridge.
Here.
Larry Elmore.
Here.
Greg Gilbert.
Here.
Kevin Monroe.
Present.
Gay Moon.
Here.
Todd Skelton.
Present.
Trey Watkins. Here. Judy Weatherby.
Here.
Thank you, Karen. It appears that we have a quorum here and that we have 100% attendance. So thank you for everybody for coming in from the middle, eastern, and western portions of the state here for this meeting. A couple of announcements, and then we'll go through the agenda here. So one announcement of note from Legal Counsel, this will be Stuart Hoffman's last formal meeting with us in his current capacity as disciplinary counsel. Maria Bush will begin handling those matters going forward, and Stuart will still be with the state, but he'll be working with multiple boards, principally other boards beyond the Tennessee Board of Accountancy. And so, Stuart, thank you for your past efforts, and I'm sure we'll see you from time to time here as the months and years go by here. The only other announcement I would have from a housekeeping standpoint is just to remind us all to speak into the microphone when we're speaking, especially to be picked up on the streaming webcast, but also for Andy and Stephen's sake as they're calling in via phone. The next item is the review and adoption of the agenda. And I have one change in order to propose for the board's consideration due to the fact that there are a couple of boards that are meeting, at least one additional board beyond the State Board of Accountancy that need legal counsel coverage. We've been asked to go ahead and move the enforcement committee report forward to the top of the agenda so that we can do that, and then that way one of our legal counsel can proceed to the other board meeting that's taking place in another room here in the building. And so with that in mind, with that change in order, any comments or concerns about the agenda? So I'll ask for a motion to approve and adopt the agenda as modified to move the enforcement committee report to the beginning of the meeting.
So move.
So moved by Larry. Is there a second? Seconded by Stephen, I believe that was. We'll go ahead and do any further discussion or comment? We'll go ahead and do a roll call vote on that.
Andy Bonner.
Aye.
Janet Booker Davis.
Aye.
Pamela Church.
Aye.
Stephen Eldridge.
Aye.
Larry Elmore.
Aye.
Greg Gilbert.
Aye.
Kevin Monroe.
Aye.
Gay Moon.
Aye.
Todd Skelton.
Aye.
Trey Watkins.
Aye.
Judy Weatherby.
Aye.
Okay, thank you, Karen. It looks like the ayes have it on that, and we'll go ahead and proceed first with the Enforcement Committee report. And just to provide a little background about what we're about, yesterday afternoon in a public notice meeting, the entire membership of the board that was present and the Enforcement Committee reviewed in detail each of the 27 cases that we had on the docket for consideration. We'll take these cases in 3 tranches, and we'll also make sure that the revisions that were made or adopted by the committee recommendation are appropriately listed here in the revised package which we received. The first tranche is what we call the consent agenda. That's case numbers 1 through 13. And these are typically cases where, other than a letter of warning, there is no specific disciplinary action proposed or to be taken. So we'll cover those as one tranche, and then we'll proceed to the other 2 tranches and discuss those in a little bit more detail. The other highlight or summary I would make from the Enforcement Committee meeting yesterday, our cases, particularly for this quarter's meeting, include a number of CPE disciplinary cases for folks that were subject to audit of their CPA based on the renewal of their license for the most recent periods, and for failure essentially to satisfy the CPE requirements. And so that will be a number of cases that we'll have, and just urge the CPA membership in our state to pay close attention to those CPE requirements, and also the changes that we'll discuss a little bit later in the legislative update to the reporting about those CPE requirements to hopefully bring along a better enforcement track record. So with respect to cases 1 through 13, we'll go ahead and take those items here. I'm just going to go through and make sure that the changes that we had submitted for 1 through 13 have been made, and we'll kind of highlight those since we had thorough discussion on those yesterday. So based on my notes, the only disposition of cases that we made as a change from what was originally recommended by staff was with respect to case number 13, where Wendy and staff confirmed this is one where a due date of October 22nd of 2019 was given for the makeup of CPE and the reporting of the augmented deficient hours. That has occurred. This person has, within the deadline, proceeded to report properly the CPE that was taken, and so that recommendation was to send a letter of warning. That was a change from the earlier recommendation where that was just simply pending. So I don't believe that there were any other changes in the proposed disciplinary recommendations for cases 1 through 13 in our consent agenda. Are there any particular cases that members would like to pull out or discuss singly before we take action on this group of cases as a group? If not, I'll entertain a motion to approve the recommendations for cases 1 through 13 in the consent agenda, part of the Enforcement Committee report.
I so move.
By Greg, is there a second? Second. Seconded by Gay. Is there any further discussion or comment on any of the cases here for the consent agenda tranche of cases 1 through 13? Not, Karen, will you please call the roll?
Andy Bonner,
Aye.
Janet Booker Davis,
Aye.
Pamela Church,
Aye.
Stephen Eldridge,
Aye.
Larry Elmore,
Aye.
Greg Gilbert,
Aye.
Kevin Monroe,
Aye.
Gay Moon,
Aye.
Todd Skelton, Trey Watkins,
Aye.
Judy Weatherby,
Here's that those recommendations then have, as recommended for approval by the board from the Enforcement Committee yesterday, have passed unanimously. So we are now going to proceed to the second tranche of cases in the enforcement section where there is new proposed discipline. For this would be in our read-ahead packet, case numbers 14 through 24. And as a result of the committee's discussions and ultimately approvals, there were several modifications to originally recommended items, and we'll go through and make sure that those are appropriately captured this morning in keeping with the intent and the motions that were passed by the Enforcement Committee to recommend to the board. So the first change was with respect to case number 14. This is, from a category standpoint, a case of fiscal dishonesty and willfully filing a report required by state or federal law, which one knows to be false. The revised recommendation for that one is to authorize a formal hearing with authority to settle via consent order upon voluntary revocation of one's license and $2,000 civil penalty. This is basically failure to comply with two separate rules with a maximum penalty of $1,000 each. This is a modification from the original recommendation, which was that did not include a voluntary revocation part of the disciplinary model. So it looks like that's been captured appropriately, but let's go ahead and deal specifically. We'll vote as a group, but are there any comments with respect to the changes that are made or proposed for case number 14? All right. I think the next change that we had from the discussions in our committee meetings yesterday resulted in, the next case was number 16. That is a case relating to unlicensed activity and holding out as a CPA firm without licensure. Ultimately, as a result of the discussions yesterday, the Enforcement Committee recommended that this be placed in monitoring status pending final follow-up, most likely at our January meeting. The reason for this status is that there are other potential disciplinary actions involving some of the same respondents on this case that will be brought to the board in January. Once those are concluded, then it will, if a referral to the DA for enforcement of the activity is necessary, it is believed that there will be a stronger case for that referral. And so the recommendation, as augmented by the Enforcement Committee, was to recommend that this go into monitoring status until January, when we more finally resolve the other matters that are associated with some or more of these respondents. Are there any questions or further comments on that disposition? Not, we'll go ahead and proceed. I believe the next change that we had was with respect to case number 17. This was a case also of unlicensed activity permit needed for each office. In this case, the respondent opened a new office. They had a firm permit, but not one for that new office location. A complaint was filed, and upon notification of that complaint, they immediately took steps to gain the appropriate firm permit for the new location. And so the outcome of the Enforcement Committee's discussion was to simply change the penalty here, if you will, to letter of warning from the earlier recommended civil penalty of $500. Are there any questions with respect to the revised presentation of this case number 17? Okay. On the next case that had some revisions to it was case number 20. Case number 20 is a failure to comply with peer review requirements case. In this particular case, the language of the recommendation for discipline was modified to be as follows: authorize a formal hearing with the authority to settle via consent order upon the respondent's payment of a civil penalty in the amount of $3,000 for providing a test work while not enrolled in peer review and failing to comply with peer review requirements, along with a requirement that the respondent re-enroll and provide proof of an accepted peer review on or before May 31 of 2020. So we just cleaned up some language from recommended to required with respect to the enrollment in peer review and completion of an accepted peer review by the end of May of 2020. Are there any further comments or questions or discussion on that case as modified based on yesterday's committee deliberations? I think that concludes the modifications for the cases in this proposed discipline section for cases, I guess it would be cases 14 through 24. So before we vote on this tranche of cases, is there any further discussion or question or comment on any of these disciplinary items?
I have a question. How do we vote if there's disagreement with, if I'm not an I vote for number 16?
You can just pull that out and vote separately if you'd like, Janet. Okay, that was number 16?
Mm-hmm.
Okay. Any other questions or comments? Well, why don't we go ahead and vote separately then on case number 16. And what I'll do is I'll accept a motion for for approving the recommended discipline there. A second, then we'll have discussion. And any comments or concerns, then we'll go ahead and vote. So is there a motion to approve the recommended discipline, in this case, to place in monitoring status for case number 16?
I so move.
Moved by Greg. Is there a second?
Second.
Seconded by Gay. Now we'll open it up for discussion and comment. And Janet, would you like to go ahead and lead off?
Well, I guess my only comment, we talked about this yesterday in the committee meeting, and based on legal counsel, our option was to refer the case to the DA, but I guess the group concluded to do that at a later time in December. I guess my feeling is that it would be better to refer it sooner rather than later, because they are continuing to operate on a revoked licenses. So that's why I would not be in favor of this particular recommendation.
I agree
Understood.
on that. I think that, our purpose is to protect, to protect the citizens, and there's a chance from now to the time we file that people can be harmed, the public can be harmed by any actions of this firm. So I think even if the DA doesn't want to pick it up until later, I think the action of this board should be to go ahead and proactively try to do anything we can to stop that public harm.
That's what I didn't understand was, what can we do? My understanding was that our action at this point was somewhat limited, and what was recommended seemed so mild that I didn't think it would be a deterrent. So I would like some input about what else could we do.
Stuart or Maria, maybe on this one, I think based on the discussions that we had yesterday, there was a view from legal that was expressed that given that we don't really control what cases the DA chooses to move on and what they don't, the notion was to present the strongest possible package to them when we do present it. But maybe if you could elaborate kind of in response to some of the commentary and questions that we've had from board members, that would be helpful.
Sure. I think what we discussed and what we came up with is put it into a monitoring status, but also to request an investigation where we can take all the cases together, investigate it, get all the information, and then present that to the DA. I think that would be better. But I would also probably recommend that maybe we could go ahead and reach out to the DA and just advise this is what's going on, and maybe get some feedback from the local DA.
Prevent this from being drawn out, as we've seen can happen. Could we specifically say that we wish to reevaluate it next time or at a certain date?
We can always, well,
Status does, right? Because
That's
that
the
allows
monitoring.
us to come back.
right. I
to
mean, the
what we're
monitoring
doing. We're trying to
status.
put him in the best position to go after this guy. So we're waiting for these other permits to expire. That way, they can't say, "Hey, we're operating on a good permit," because they have one that's still active. Correct?
Correct.
So
What
what
would
he's
pre-
saying is that at the end of the year, all of the permits will be expired.
Okay. So that's what would prevent this from dragging on, like another case we talked about?
In the next meeting, there will be 2 other complaints that will be addressed.
What if they stop practicing? That would solve our issue, but they could actually just go up through the end of the period and then just stop practicing, and then I guess it's resolved the issue that we as a board have. But
Right, but if that happens, it will still be brought up in January.
Okay.
We already have one office location that is operating without a valid permit, and then we also have one of the owners has a revoked license as well. And so I think the thing that gives me comfort, Pam, is that we know that by the end of December, the remaining valid, if you want to call it that, license is going to expire, and then that will also then be the subject of the complaint because it's not being renewed. And Janet, I'm not in disagreement with the concern or kind of where you're headed in terms of we want this to stop, and Judy as well. I just my fear is that if we go to the DA with an incomplete or a partial case, we may not get them to act on it given whatever their other portfolio is. And I just as soon try to put these people out of business because they've been flaunting our rules for quite some time. And so it's not an easy, it's not, to me, it's not black and white, and it's just how best to proceed. And I understand the sentiment to want to do something now as much as we possibly can. And I like the idea of reaching out to the DA and taking their temperature and maybe previewing what's likely going to be coming their way with emphasis from this board, because this is about as egregious as it gets to willfully continue to practice and hold out as a CPA firm on revoked or non-issued permits. Any further comment or discussion, Greg?
Janet, I also agree with Kevin's remarks. I would like for us to be able to immediately stop this action of the CPA firm. But my recommendation or my motion was based on legal counsel's advice to us. So to just help us build the strongest case. So.
Okay, other questions or comments? So what we'll do is we'll call the question just solely on this particular case that we pulled out here with respect to this item for unlicensed activity, and we'll go ahead and take the vote on that and then proceed forward depending on how the vote turns out. And so we have a motion to approve the recommended discipline, which in this case is to place in monitoring status. That's the motion before the House here this morning, and request for investigation.
May I ask, would it be possible, or is it, our next meeting isn't until January, so requesting an investigation, and if you reach out to the DA, and the DA's like, let's go ahead, nothing can happen until we meet again. But if we maybe consider making an adjustment to our recommendation, where if you reach out to the DA and the DA says go ahead, you would have authority from this board to move forward. Because right now nothing can happen until January, period. Even if the DA says, oh yeah, we'll take that on. I don't know. I mean, just a thought.
We're talking 2 months. How long would it take you to get an answer as to whether you can move forward?
Can't really answer that question until I talk to the DA. And I would think that if the DA wanted to move forward, then I don't believe we would need authorization
Oh, okay.
from the board. I mean, we would go ahead and present the evidence to them, and they would move forward on their own.
Let's go ahead and call the roll on the status of case number 16. And again, a vote for approval would be to follow the put in monitoring status and request an investigation course of action. And then knowing that we're likely going to take up additional violations associated with the respondent in January. Karen, go ahead and call the roll.
Cindy Bonner,
Aye.
Janet Booker Davis,
Aye.
Pamela Church,
Aye.
Stephen Eldridge,
Aye.
Barry Elmore,
Aye.
Greg Gilbert,
Aye.
Kevin Monroe,
Aye.
Gay Moon,
Aye.
Todd Skelton,
Aye.
Trey Watkins,
Aye.
Judy Weatherby,
Okay, so the motion passes on case number 16. Now we'll go back and deal with the tranche of cases 14 and 15 and 17 through 24. And we'll vote on those as a group unless there are any others that we would like to pull out and deal with separately. So we've reviewed the modifications that the Enforcement Committee made yesterday and its recommendations. Are there any other questions or concerns on cases 14 and 15 or 17 through 24 in the proposed discipline category? Not, Karen, will you, well, first is there a motion to approve the recommendations with respect to those cases 14 and 15 and 17 through 24.
So moved.
Moved by Janet. Is there a second?
Second.
Seconded by Greg. Any further comment or discussion? Okay. Karen, will you please call the roll on that?
Cindy Bonner,
Aye.
Janet Booker Davis,
Aye.
Pamela Church,
Aye.
Stephen Eldridge,
Aye.
Larry Elmore,
Aye.
Greg Gilbert,
Aye.
Kevin Monroe,
Aye.
Gay Moon,
Aye.
Todd Skelton,
Aye.
Trey Watkins,
Aye.
Judy Weatherby.
Thank you, Karen. The motion passes. And so we have 3 remaining cases. These were representations. These are cases that the board has taken up previously, but there's been a new or updated information since we last acted on those cases, and so we'll deal with those as well. So case number 25 was a failure to comply with peer review requirements case. This is one where the enforcement committee, after deliberation, agreed that we would allow for an informal conference with the respondent who wants to meet with staff and a member of the board to further air his views on the matter. The enforcement committee recommended that we would go ahead and proceed with that approach. That would any change in status would still require subsequent full board approval. It would run through the enforcement committee at the next meeting and the board before any change in status is ultimately determined on this case. Case number 26 was an unauthorized use of the CPA designation case. And there the update was that the previous recommendation that had been approved by the board was for a $5,000 civil penalty for using the designation. The update was that there was subsequent discussion with the respondent on this one, and he now has a much more full understanding of the licensing responsibilities and use of CPA designation responsibilities here, and he has basically taken action appropriately. And so here the revised recommendation or the new recommendation is to authorize a civil penalty in the amount of $1,000 rather than $5,000 for using the designation of CPA without a valid license in Tennessee. And that was approved by the enforcement committee in its deliberations yesterday. And then finally, the last case is one with respect to potential dishonesty in the performance of services as a licensee. And the particulars of this case were that it is an old case, meaning the underlying potential facts occurred back in the 2012 timeframe. This case was taken up again by current staff who then reviewed the original investigation that was performed several years ago. And it was determined based on that review that there's really not enough there to proceed with a case. And so the recommendation on that case is to go ahead and close it. And I think yesterday in the enforcement committee deliberations, staff indicated that there were no other what I'll call similarly old or malingering cases like that are in the portfolio. They are subject to being reviewed and monitored both on a monthly and a quarterly basis, and this is really the last of those kind of cleanup actions to take care of the last of the old cases. So the recommendation here on this one is to close it with no disciplinary action to be taken. Is there any further comment or discussion or question on any of the outcome recommendations for these 3 cases? I'll entertain a motion to approve the recommendations for each of these 3 cases, numbers 25, 26, and 27.
So moved.
Moved by Gay. Is there a second?
Second.
Seconded by Larry. Thank you. Any further comment or discussion on these 3 cases?
I would like to say number 27, the explanation is much better now. I can actually understand what we're saying.
I actually would like to correct. I put the wrong year in there on when our prior investigator left. It should be 2017. Not that that's a huge thing. Explanation, Larry, that we added.
actually flows a lot better now. But
I think the concern was just making sure that there was something in the record that would indicate, the
what caused
particulars
the delay?
around the delay.
Yeah.
Yeah.
And I think this does that.
Okay, good.
That's a question on 27. Is this firm current on their peer reviews and no issues with any of that now? Okay.
Any further questions or comments? All right, Karen, will you please call the roll on these three cases?
Andy Bonner,
Aye.
Janet Booker Davis,
Aye.
Pamela Church,
Aye.
Stephen Eldridge,
Aye.
Larry Elmore,
Aye.
Greg Gilbert,
Aye.
Kevin Monroe,
Aye.
Gay Moon,
Aye.
Todd Skelton,
Aye.
Trey Watkins,
Aye.
Judy Weatherby,
Aye.
Okay, that motion passes. And the only other item from the Enforcement Committee relates to the complaint report. So yesterday, as a committee, we reviewed the summary of the quarterly complaints and actions report as an informational item, and that's included in our packets. And that would conclude the activity with respect to the Enforcement Committee. So with that, if I can find it, we will go ahead and proceed. I may need to borrow your agenda here for just a minute. Buried it. We'll go ahead and proceed back to the order in the agenda. So thank you, for, board members, for patience in allowing that move on the Enforcement Committee up in the agenda so that that our legal counsel could get to their other meeting. The next item on the agenda then is the approval of the meeting minutes from the meeting of July 30, 2019. I'll entertain a motion to approve, and then we'll open it for discussion.
Move that we approve the minutes.
Okay, thank you, Greg. Is there a second?
I'll second that.
Second by Larry. Discussion or comment on the minutes? Okay, we'll go ahead and proceed with the roll call vote. Karen?
Andy Bonner,
Aye.
Janet Booker Davis,
Aye.
Pamela Church, Stephen Eldridge,
Aye.
Larry Elmore,
Aye.
Greg Gilbert,
Aye.
Kevin Monroe,
Aye.
Gay Moon,
Aye.
Todd Skelton,
Aye.
Trey Watkins,
Aye.
Judy Weatherby,
Aye.
Thank you. That motion passes and the minutes are approved. And Kay, thank you also for the review that you do as our secretary on those, and having to also review the video of the meetings here to make sure that the minutes accurately reflect the disposition of items there. The next item on the agenda is the Executive Director's report, and I'll turn that over to our Executive Director, Wendy Garvin.
All right, good morning. The Executive Director's report should be on your iPad, and you received this in advance as well. The first section of the report just deals with our future meeting dates that have been previously approved, and I've added one proposed date there for Tuesday, January 26, 2021. So we'll take a vote on that at the end of the Director's report. That is the last Monday, Tuesday of January, which is typically when we've been having that meeting. Commerce and Insurance Leadership. Unfortunately, our schedules have not aligned with our new Assistant Commissioner, but he is eager to come introduce himself to you all. But it didn't work out this meeting either, so we're hoping for January. That's Assistant Commissioner Toby Compton. The change that I note in the Director's report is that we do have a new commissioner who was appointed by the governor on September 5th. Hajan Mayinda is his name, and he will serve as the commissioner. I did last week. Very, very nice gentleman, and hopefully we'll be able to arrange a if you have the electronic version of this, you can click and see a little bit about his bio. Sunset hearing. I know Kevin mentioned a little bit about this yesterday, but we did attend the sunset hearings for the Board of Accountancy back on August 21st of this year, and a pretty extensive package in preparation of the meeting. I thought the meetings went well. There were very few questions. In fact, we were congratulated for having all positions filled and for the attendance of this board. So there are a lot of boards that struggle with attendance, and they've had to implement attendance requirements. But this board has done a very good job with that. So congratulations from them to you all. And of course, it was recommended that at that meeting that we have a 6-year extension on the board before we go through the process again. That will come up now in the legislative session and hopefully pass without issue then. NASPA meetings, of course, their annual meeting is next week. I am attending along with Larry, Greg, Andy, and Evan. Sorry. So we are attending next week. So there should be some good information on the evolution project that's going on. Also wanted to note, well, I will note that in just a minute. And then the executive director and legal conference is in March, and Sherry and I attend with our legal counsel, and that's focused on our specific jobs within the state, and we get to interact with those across the country in the same positions. Our fall newsletter, we're in final stages of that, so we are hopeful to get that to legal next week and then out to the licensees the beginning of November. Other communications we did, hopefully you all saw, we did send an email last week. We have had some questions about the new CPA requirements. And so we sent an email last week specifically related to CPE to try to clarify those requirements and help answer the questions that we had received. And then we encouraged folks who had not logged in to NASPA's audit service to use that if they so choose. And those folks who had not logged in should have received a subsequent email with login information, I think within 10 minutes or so of that initial email. The AICPA Board of Examiners, this is my first year serving on that committee, and we met on October 1st in Orlando, and I highlight some of the things we talked about there, mainly lower volume on the exam, and then the practice analysis that they're going through in order to try to remove some things from the exam so that they can add some technology related items that are so important in the profession these days. So one of the things I wanted to highlight here is for those of you going to the annual meeting, they have scheduled an optional session for you to see how the exam works now. So if you want to attend that, I believe it's breakfast on Monday, or if you need any information, just let me know. I'll send that to you. But it would be a look at the computerized exam, which most of you were not part of when you took the exam. NASPA Compliance Assurance Committee, I did meet with this group on September 17th at NASPA's offices here in Nashville, and we met with the AICPA leadership involved in peer review and discussed matters regarding oversight in regards to that. So there's kind of two major issues. One is a rewrite of their Chapter 3 oversight handbook, which deals with who can sit on a peer review oversight committee. So it was some good conversation. They're actually having a meeting today at 1 Eastern to finalize that rewrite and give guidance on confidentiality and aspects regarding oversight. The other thing that we've been bringing up for about a year is the board staff inability to get some basic information about the status of an individual's peer review or a firm's peer review. So we don't get enrollment. We get a notification when they've enrolled, and we can see if they're enrolled typically, but we don't know when they're due for a peer review, so we don't know when to expect those results to come through. So there are several pieces of information, and luckily they're working on making those available to us. And again, they're going to discuss that in the meeting today and hope to start that process at the end of this year. So that's good news for us. Exam results attached to my director's report is the most recent, the third quarter exam results for Tennessee and nationally. The numbers of individuals sitting for the exam continue to be down a bit. So I believe both the AICPA and Naspa have modified their revenue projections as a result, because it's a fairly significant number. Some of the reasons are, when you have a good economy and people can make money doing other things, they choose to go that route sometimes rather than pursuing the CPA exams. That's one of the items. Performance metrics. These are the items that staff works towards each day related to goals of the department and of the governor. We monitor how many days it takes us to license an individual, so you'll see our numbers noted there. We also, our goal is to resolve 90% of complaints within 180 days. Are at 94% as of the end of September, and we typically, that's our range, is 91 to 95%. Online adoption rate, that's how many applications that are submitted online versus in paper. So we have an excellent adoption rate in that department. And then the last part of the report is the new licenses issued and the overall licensing population. That concludes my report. If anyone has any questions.
Just one comment, and realize we have one action item to approve that new date, so we'll pick that one up in just a minute. But just to elaborate on the day that Wendy and I spent up with our legislative branch here in the legislative offices, it was a lengthy day, but I will say Wendy was incredibly well prepared for that meeting and for the questions that were asked by legislators in session and in the hall-to-hall meetings that we had throughout the day. And I think I don't want to brag or anything in particular, but what Wendy said about being congratulated for the diligence of the work that you all are doing, the fact that we've got a full board fully appointed in a timely manner, and that we have a great attendance rate, was noted, and is not necessarily the case in the other couple of dozen or so boards that they oversee. And so hats off to Wendy for doing a great job on that, and really just thanks to each of you for being willing to serve and to work hard at it. So thank you. With that, we'll take up the action item, which is to approve a future meeting date. This is for a board meeting on Tuesday, January 26th of 2021. Is there a motion to approve that date?
So move.
Moved by Greg. Is there a second?
Second.
Seconded by Todd. Is there any further comment or discussion? Okay, Karen, will you call the roll?
Andy Bonner,
Aye.
Janet Booker Davis,
Aye.
Pamela Church,
Aye.
Stephen Eldridge,
Aye.
Larry Elmore,
Aye.
Greg Gilbert,
Aye.
Kevin Monroe,
Aye.
Gay Moon,
Aye.
Todd Skelton,
Aye.
Trey Watkins,
Aye.
Judy Weatherby.
Aye.
Motion passes, and that date is going in the books here. The next item in our agenda is with respect to the review and approval of committee assignments, and just a little background for the thousands that may be watching on live TV here. Right now, the Board of Accountancy has 4 standing committees. The Executive Committee, which provides executive guidance to the board and staff and monitors the fiscal operations of the board, also provides guidance to the Executive Director on administrative and personnel matters and assists in the legislative process as requested, as well as overseeing the Peer Review Oversight Committee as one of those committees. The proposed membership for that is basically by virtue of the inclusion of the officers of the board. That would be Kevin Monroe as chairperson, Stephen Eldridge as vice chair, Gay Moon as secretary, and Trey Watkins as the most immediate past chair. The next standing committee is licensing. This committee evaluates difficult experience and education claims from CPA candidates that are recommended for its consideration by the staff. They provide review and oversight of the CPE process. They discuss issues that affect licensees and applicants, and they evaluate exam-related matters that lead to licensure. And the proposed membership of that committee for fiscal year 1920 is Gay Moon as the chair, Pam Church, Stephen Eldridge, Ray Gilbert, and Judy Weatherby. The third committee is the Laws and Rules Committee, which has the task of reviewing current laws and rules and suggesting changes as needed and reviewing policy. And the proposed membership of that committee would be Chairperson Janet Booker Davis, also Andy Bonner, Larry Elmore, Trey Watkins, and Judy Weatherby. And then the Enforcement Committee, and we've already seen a little bit of a dose of what they do earlier this morning. That provides review and oversight of the investigation and legal action program and recommends disposition of cases to the board. And the proposed membership of that committee is Andy Bonner as chair, Janet Booker Davis, Pam Church, Larry Elmore, and Todd Skelton. At the last meeting, we kind of made a call if you had a preference for a particular committee or willingness to serve, just to get that information to Wendy, and many of you all did that, and so we tried to construct this based on the feedback that we got or the input that we got. But this is one where I think we need a motion to approve with respect to the committee assignments, and so I'll entertain a motion, then we'll open it up for questions or discussion.
So moved.
Move to approve the recommended committee membership. Is there a second?
Second.
Seconded by Greg. Any further comment or discussion? I just appreciate everybody's willingness to serve. Many of y'all are serving not only on one or more committees here, but also are pulling extra duty serving on Naspa committees or AICPA committees, and it's just a testimony to the hard work and diligence of the folks that are sitting on this board, and many hands make light work, so I appreciate that very much. We'll go ahead and call the roll here, Karen.
Andy Bonner,
Aye.
Janet Booker Davis,
Aye.
Pamela Church,
Aye.
Stephen Eldridge,
Aye.
Larry Elmore,
Aye.
Greg Gilbert,
Aye.
Kevin Monroe,
Aye.
Gay Moon, Todd Skelton,
Aye.
Trey Watkins,
Aye.
Judy Weatherby,
Okay, thank you. That motion passes. I think what we'll do is it's only 9:20, so we're less than an hour into our meeting, and we've already had the Enforcement Committee action. So I think we'll go ahead and proceed at least with the first of the next applications for review or informal appearances that we have, and then depending on how long those go, we'll time a break accordingly here probably shortly thereafter. So the first application for board review informal appearances relates to the appeal of a denied CPA license application with respect to Lloyd Schumann, who is present here at the meeting. I will need to recuse myself from the deliberations and the voting because my firm had an affiliation with one of the entities that was involved in this case, and so it's most appropriate that I abstain from that discussion. So on this one, the presiding officer is going to be Gay Moon, our secretary, here in cooperation and working with our legal counsel to present this item because of my need to recuse. And so, Gay, I'll turn this over to you.
Okay. Mr. Schumann presented an application for licensing in the state of Tennessee. Our staff chose to deny it because of some civil proceedings. I'll let legal start this off with discussion and how to proceed.
Yes, thank you. So I'm just going to read a quick excerpt giving a summary of what happened, and you all have the documents in front of you. And then Mr. Schumann at that, Mr. Schumann, okay. And then at that time, Mr. Schumann can speak to the board. So in the case of Mr. Lloyd Schumann, the documents received by the board convey that the applicant entered into a settlement with the United States Securities Exchange Commission. This application was denied under TCA 62-1-106 due to lack of good moral character. Based upon Mr. Schumann's discipline assessed by the SEC, his application was denied under the history of dishonest acts. At this time, the board may allow Mr. Schumann an opportunity to make a statement. Furthermore, the board will have an opportunity to ask questions directly regarding his conduct. Yeah.
All right. First of all, I'd like to thank the board for allowing me to speak before you. So is this where I just say what I think? Okay. All right. I'd just like to say I've worked in the accounting profession for over 20 years in accounting, audit, finance, and compliance without any blemishes on my record, other than the allegations from the SEC that did not go to court. It was settled civilly with no admission of guilt. I have 5 certifications by 3 governing bodies, 3 from the IIA, 1 from ISACA, and 1 from ACFE. The IIA conducted an ethics investigation based on the settlement, and they dropped the investigation due to the fact that the case was dismissed with prejudice and did not contain any admission of guilt. Other than that, I'm very limited in what I'm allowed to say about the case. I've never done one of these things, so I don't know what the next step is. So I guess I'll entertain any questions.
Thank you for coming this morning, and I will open it up to the board for any questions that you might have for Mr. Schuman at this time.
I'll be honest, I'm struggling with this issue because you've admitted no guilt. You haven't been convicted of anything, which we understand that as a board. My problem comes in with the ethical, moral question. Something happened here. And yet, I don't know that I see any remorse. I don't see any contrition as to what occurred or how this happened. And I don't know if you think you didn't do anything wrong. I don't know if you think that you've, nothing wrong. I don't know your state of mind in this issue. That's where I'm struggling with your case.
There's a lot I'd like to say. I'm just afraid that...
Which puts us in a bad position. I hope you understand that. Your inability to speak on this matter makes this very difficult for us to come to any kind of conclusion. So I don't know where to go with that. I'm being honest with you.
Right. I'm trying to figure out what I can say or not say without...
Mr. Schuman, this is Stephen Eldridge. I'll just be blunt.
Yes.
We've got, a list of facts that have been stated. The question is, are you guilty of those?
Those aren't facts. Those are allegations.
Well,
And-
we'll call them allegations. The list that we have of that stuff is, are you guilty of those items?
I'm not allowed to say. I literally signed something where it's no admission of guilt, but I'm also not allowed to deny.
But you understand that puts us in a very precarious position,
I
right?
understand, yes.
Right.
I would.
You're
I
not
wish you
denying
had made
that
different
you're not-
choices in the past.
Absolutely.
Let me ask you this.
Absolutely. I would have done everything different, not to have the appearance of that's.
Mr. Schuman, when you signed one of the agreements, you recognized that the consequences of the allegations might prohibit you from participating in licensing boards. That was item 10 of consent of the defendant, Lloyd Schuman. Did you, when you sat for the CPA exam, were you aware at that time that those restrictions might be in place and would put us in a awkward position?
when I signed versus when I actually took the exam. The time.
It was in the same month.
Just for the record, it's February 2019. The consent was signed.
February of 19 or
Yes, 2019.
okay. And you sat for the exam.
Started it in 2018 and took.
What type of work are you doing now?
Right now, I'm doing business consulting.
Self-employed.
Yes. Due to the settlement.
What do you mean by due to the settlement?
When my previous employer was made aware of the settlement, they terminated me on the spot. It was Alsac St. Jude, and anything that might negatively impact their ability to fundraise,
I have a question. I'm assuming you are familiar with the information that we have in front of us that document the facts of the case. Are you aware of what we have and what we've read?
I believe so, yes.
Okay. So is there anything in those documents or that information that you would think would not be factual?
There are some things I can't really go into it since legally I'm not.
Just for a point maybe of clarification, this might help with where Mr. Schuman is going with all of this. If you'll note on page 4 of the consent of Lloyd Schuman, that is in paragraph 11. It's towards the top of the page, but he's prohibited from creating the impression that the complaint is without factual basis. So that's where we're running into an issue, I think. That said, we can proceed. I didn't mean to interrupt.
So,
but.
Oh, that's
So
okay.
just as a follow-up to that, you said a while ago that you wish you had done things differently.
Yes.
So is the reason for that because what you did was wrong or because you wish you hadn't got caught?
I wish I wouldn't have put myself in a situation where the appearance of doing wouldn't do.
So in your opinion, it was just the appearance of doing something wrong?
I don't know if legally I'm allowed to say that. There is a lot of things I would like to say, but if I say the wrong thing, that could get me in a lot of trouble. And
So this may seem like a stupid question. I don't mean this to sound
that's fine.
any way than what I intended it to be.
Right.
But what did you hope to accomplish by coming today if you can't answer any of our questions?
State that the case, these are not legal facts.
So you are saying
These are
they're not legal.
allegations.
You're not guilty. I mean, this is
Legally.
where I'm struggling because
Yeah.
it's convenient that you've got these order that says you can't talk about anything. And
It wasn't
Tom,
my
you
choice.
come up before this board, you can't
Yes.
answer any question. And because I can't get an answer. And I agree with Mr. Elmore in the fact that I don't know what you hope to accomplish today. A feeling as to how we can protect the public from individuals who do bad. Not feeling anything from you as far as whether or not you feel like, hey, remorseful or I shouldn't have done this or I shouldn't have, because you can't answer a question. And that's a real problem.
I do feel extremely remorseful the whole thing happened. wish it never did. I came here to say I've been in the industry, working in various fields in accounting. I have 5 certifications. IA did an investigation based on it, and I know, but they did drop it based on the no admission of guilt, and it was dismissed without prejudice. I'm sorry, dismissed with prejudice. Sorry, I'm not a lawyer. Like to continue in the accounting field.
I have a question, Mr. Schuman, and maybe I'll ask Maria before I ask this. Is it okay? The way I interpret this, he cannot deny the allegations, but he could tell us if these acts were committed. Isn't that correct? I mean, he can't deny them, but he can admit guilt.
I can speak to what happened.
Okay.
I just want to be careful that we're not a court of law.
Right,
And
right.
so, yeah, absolutely, that we're not determining whether or not, Mr. Schuman is guilty, but whether or not you all believe that you have enough information to ascertain that he did or did not engage in dishonest acts that would amount to a history of good moral character. And so that's kind of where we have to go on
And
So
that's
that.
the
could I
problem.
ask a specific question then?
Sure. Can I
Yeah, sure.
ask the
Yeah.
attorney a question? In your legal opinion, am I allowed to say position what I said?
Well, I just don't want to speak on your behalf.
Right.
I can't give you legal counsel on the issue, but you're free to,
When I did give my deposition, there was I'll do a high level. There was a lot of I disagreed with a whole lot of.
be sure that when we're talking, the mic picks up when it's
okay,
right.
sorry.
Yeah, there you go.
And I'm sorry, I didn't mean to interrupt you.
Oh, no. You were trying to answer, I think, my question.
Mr. Schuman, you mentioned that you're sorry for what happened or remorseful for what happened. So what happened? What are you remorseful for?
That I put myself in a position where the appearance of wrongdoing occurred.
What does that mean? I mean, what happened? What do you think you did? I mean, I'm driving in the dark here, trying to make a decision with no,
Right.
What do you think happened?
When I was at Verso, I bought stock in the company throughout my 6 years there. I was going by what the executive membership were saying in newspaper articles and trade publications, and I was buying. The paper industry was consolidating. We were owned by Apollo Management, and our management kept saying that industry is consolidating. We either have to merge with someone or acquire someone or be acquired, or we're going to go bankrupt. So I knew 3 things were going to happen. 1, we would buy someone. 2, we would be bought. 3, we'd go bankrupt. And I knew Apollo Management was pulling all the strings of what was happening at at Verso. I was betting that one or two would happen, and I was betting heavy on it. I wasn't on the team that did any due diligence stuff. We weren't part of a blackout period where you can't trade stocks. But I should have known it would have the appearance of knowing things that the public might not know.
What about the text exchanges between you and the other individual?
With the Verso stuff?
Wasn't that on there?
Yeah.
Yes.
I turned over thousands. I gave them everything.
I mean, did you alert another individual to buy stock with insider knowledge?
No, I didn't have any.
You didn't have any knowledge.
Not that I don't know if I'm allowed to answer. Under deposition, I gave that answer.
Tell us what the text messages were about.
Basically, what I told you guys, that we traded stocks all the time, all these different stocks, and we would bounce ideas off each other. And
I read that as there's an imminent transaction about to occur, and you need to get in on this. Am I wrong?
I did not make one like that. We talked for years on this stuff. They cherry picked from were also text messages that said, I have no idea what's going on. This is just thoughts.
So in the weeks leading up to the, can't remember if it was at no point in time you didn't buy any large
I did.
shares of stock close to the time that the merger occurred.
No, I did buy stock, but I also bought stock throughout the year.
But at any time, did you close to the time that this situation occurred related to these allegations, you didn't buy an unusual amount of stock?
I bought a lot. I was dollar cost averaging because the price kept going down. I had done the same thing with other stocks I was in that were going.
I guess in this information that I'm reading, it says Schumann accumulated, it says you accumulated an unusually large concentration of shares,
But
close to
90%.
I guess that's what would make it look bad if you bought, this unusual amount of shares close to the time that this public announcement was made.
I understand.
And then sold them fairly close after.
Well, right, but most people are going to sell
that
on
happened?
the day. It's buy when you think something is going to happen and sell on the news.
Well, as long as the public knows.
Well, I agree. And I agree of the impression that it gives, or the appearance.
So are you saying that that's what happened, that you bought this unusual amount of shares close to the time of right before this public announcement, and then you sold right after the public announcement?
Yes, but
Yes, you did that?
I did the same thing a couple of years prior. Like when I first started at Verso, I bought shares. It was like at $2, and then it went down to 80 cents or something. And we tried to buy New Page, and the stock spiked up to $3, and I sold. So I thought the same thing was going to happen again.
Why did you think that?
That turned us down that time, and they went into bankruptcy. So management was constantly saying there's consolidation in the paper industry. Other paper companies were buying each other. And I knew one of the three things was going to happen. One, someone was probably going to buy us because we were small. Two, we were going to buy or merge with somebody. Or three, we would go bankrupt. And I was betting on Apollo not letting number three happen.
There's a series of text messages, and I hear again, we're not trying to determine guilt or innocence here, but on page 13 of these documents that we have, there's a list of text messages you had with a person named James. He was asking you what was going to happen and when, and you said, I need to get off here for just a minute, go talk to one of the accounting managers to see what they think about it. So you were getting inside information. It says, need to cut you off so I could talk to one of the accounting managers. He said they're still planning on the equity raise, but it looks like later in Q1. So that's definitely getting inside information to advise someone else what to do.
I don't remember that text message, and we weren't.
Well, my takeaway from what you just said to me in response to my questions is that that's potentially insider information that you were just telling me.
Sure.
Well, if the public wasn't aware of the same things that you were aware of because you worked for the company, I mean, to me, that's what that sounded like, was you had insider information.
Oh, that was all public information that Apollo owned us. In articles, management made these statements.
What about the PwC due diligence and the text messages on page 7 about that? When was the due diligence? The report was printed a few weeks ago.
I have no memory of that one.
I have to ask a question about the timeline. So you started taking the CPA exam in February of 2018. Isn't that what you said? Anyway, that's not really my question. My question is, and this is just lack of knowledge about how these things operate, but on page 19, the request for jury trial was May 9th, was in May, but the consent orders in prior to that in February. How does that work?
Yeah, I was looking at those dates. I'm not sure. Okay, well, Wendy is going to speak to the exam dates, and then I'll look at that issue.
The election was passed on May 21st of 18.
If I remember right, the SEC proposed the settlement in late 2018. They had to go through their process of getting it approved and putting the money in, and it had to be approved by court.
I was curious as to why on page 19 of the first document, demand for jury trial was May 9th, 2019, when you signed a consent order back in February.
So I know that the SEC filed the allegations, and there was probably a request for jury trial, and they settled, and it looks like the court accepted the settlement and entered it in as a final judgment. So
that was another May date. That still didn't answer my question about page 19.
Okay.
So basically you started preparing for the CPA exam after all of this transpired. Is that, or you decided to pursue that after all this had transpired a few years before? Is that correct?
Yes.
Okay. And as you're studying for that, I mean, there's a lot of information about the requirements as a CPA, that you need to have, the ethics, as you were doing that, any thoughts in your mind that you would have trouble obtaining that license as a result of these things, these allegations?
Yes. But
So you're not surprised to be here?
correct.
Okay.
And I wanted to get this CPA. Thought it was worth a shot. It means a lot to me.
What was your position with Verso?
I was in an internal audit.
What level? You're an
Uh,
auditor or manager or?
I started as senior auditor, and by the time I finished, I was manager.
Did that company have any conflict of interest or other policies regarding employee stock purchases?
I believe so.
And you were in compliance with whatever they were? You didn't have any conflict of interest with, according to your company's policy?
As I'm not allowed to deny or disagree with anything they wrote, I can't answer that.
One more question.
oh,
Go
okay.
ahead. Sorry, I didn't realize you were still going.
No, I was just going to say there are a lot of allegations in there which have not been proven as fact.
I don't know if this point might help the board at all, but Mr. Schuman did enter into this consent agreement on his own free will. And so part of that is, close to $260,000 in disgorgement to the SEC, and also an agreement to not deny the factual basis. So that was his choice he was not forced or coerced into signing this agreement.
Otherwise, he'd have gone to trial. So,
trial was
choice or no
an
choice.
option.
I get it. I mean, it's.
So you paid. Are you responsible for that settlement amount?
Yes.
Plus, you agreed to not to deny. Okay.
And I'm only allowed to point to it saying there's no admission of guilt. I'm not allowed to deny. And I settled because they made the offer to settle. And if we went to court and lost, the penalty would be triple. I would have to pay for the government's court cost, plus the cost for me to fly my attorney out there.
Free will. We get it.
Oh, well, okay.
I'll tell you where I'm struggling right now. I'm getting the sense that you almost feel like you did nothing wrong. And pardon me for reading it that way, but your responses and your answers have led me down a path that makes me think this was unjust. And I'm struggling with that.
I'm sorry it comes off that way. Just legally, since I'm not allowed to say something contradictory.
You're talking about disagreeing with some of the facts. You're talking about
Right.
different things. There's certain things you're saying
Yes.
that give me the impression, not your non-responses, it's what you're telling me that's giving me the impression that you really feel like you've accumulated stock over time. You did these things over, you traded on information that was common to the industry. That it almost makes me feel like you think you're a victim in this situation.
Well, I guess my concern is that you said you were an internal audit manager. Is that right?
At the end of my career there, yes.
And I guess my thinking is that in a lot of cases, in my experience, internal audit, particularly managers, have a lot of potentially confidential information about their employer, their company. And I don't know the size of Verso and all of that, but and you did say they had conflict of interest policies that employees were required to sign, that kind of thing. And so I guess my thinking is that given that background, you would know the potential repercussions of this type of situation, or should know.
Right.
And having taken the CPA exam and all of that, then you really should know. And in the absence of other convincing information that you can't tell or talk about, I mean, our responsibility is to protect the public. And without some other compelling information, I don't see how, in my opinion, I would be doing, I'll just speak for myself, be doing my duty of protecting the public if I don't know enough information. So to me, that's the problem that I would have, in that, I mean, I just don't have enough information to say one way or the other.
One more question I have. How long did you work for Verso after this, this all came?
I worked for them for 6 years, and then they moved offices to Ohio from Memphis. I was offered a chance to move with them, and I declined.
And so at what point, how long, so you remained employed with them for how long after this trading took place? And you left of your own accord?
Sorry. Yes.
So you were not terminated, you
Correct.
resigned?
Since they were leaving Memphis, they asked me as part of the group to stay on until the end, so they could wrap everything up and move to Ohio.
Did the SEC, I want to ask that more clearly,
Yeah.
Did the SEC investigation, the notice they provide to commence, did you receive that before or after you ended your employment with Verso?
Before, it was just an information request. I believe that was in 2016.
And when did you complete your employment with Verso?
2016, I think, a few months later. Or it might be 2017 when I left there. I don't remember.
Mr. Schuman, were you generally aware of insider trading rules prior to purchasing stock?
Yes.
And did the company provide any guidelines with respect to insider trading? Were there any internal documents? I know you had a conflict of interest policy, and maybe insider trading was addressed in that.
I think it was an all-in-one document that covered a lot of things.
Yeah, and according to the allegations, Mr. Schuman signed the Verso company insider trading guidelines in 2011.
Legal, it says all charges, or let's see, all claims in this matter are dismissed with prejudice. Not being a lawyer, can you give us a definition of what that means?
So, so the court retained jurisdiction over this matter by, if you'll read the next sentence, it says that they're going to enforce the consent agreement. So the consent agreement that we've all been discussing and the stipulations, those are binding under a court order. So the allegations that were filed in the SEC, and this kind of speaks back to the demand for jury, those were taken into account it's acknowledged in the consent agreement, and then the court took that, dismissed everything, and said we're just going to retain jurisdiction and enforce this settlement agreement. So it never went to jury, and it was never. I don't know if that answers your question, Pam, too, but does that answer your question? Kind of, maybe. Todd's still confused.
I think what you're asking is quite trying to boil it down most simply. Prejudice is an indication of whether the case can be brought up again. And if it's dismissed with prejudice, it means you can't bring it back up. So you couldn't re-bring the charges.
Kind of like the double jeopardy.
Yeah,
thing
except
with
this was a
except
civil
it's
context. But
yes.
yeah,
Okay.
same general idea.
Okay. Okay.
Different constitutional issue, but general way to look at it, yes. Adding value every day. I'll be clear on my position on this one. Insider trading allegations are serious, and I know you're in a tough spot, and what you can say, and navigating that is difficult. But I do think that we're in a position of having to look at what the allegations in the complaint are, and understanding that you're in a position to not be able to deny those, and you're not having to admit them either. I think you're welcome to, but not having to deny them. We have to take that complaint at its face value, and if that rises to the level of a dishonest act, then that covers our what our decision making threshold is. So I think it is clear to me, but it's commend you for going through the process and passing the exam, and I know this is a difficult thing in your career, but there are consequences, and see where it lands. But
So how will all of this that's happened inform your judgment going forward?
To do everything I can to not be put in a situation of wrongdoing or appearance of wrongdoing, or look like I'm trying to hide information, which when I was terminated from my last job and trying to get other jobs, when I would apply and I would get phone calls from, the very first thing I would tell them is about the case. My attorney said legally I'm not obligated to tell them about it, and it probably, according to him, it probably wouldn't come up in a background check, but I wanted to be upfront and honest. Everything I do.
Well, I appreciate you coming and sharing what you felt like you could.
Right.
And
all right. Well, to answer your question, at the time that I was buying the shares in question, I think I was a senior auditor, and the company did not use us in any capacity for any deals or anything they were doing. They went strictly with consultants. And I just want to humbly ask the board and sincerely ask you to consider reconsider the denial of the license, and to repeat that the items in the allegations legally I don't believe are facts, and the IIA did an investigation into it also and dismissed the investigation because it was without guilt, without admission of guilt, and dismissed with whatever the one and done thing is. See, okay,
You don't believe they're legally facts.
right,
What does that mean?
that they're not proven.
But they could still be facts. I guess you can't answer that. I mean, I guess to me, facts are facts, whether they're proven or not. You would know whether they're facts.
Correct.
Somebody
And
else
they're-
knows.
I make a suggestion we
Anyway,
move this to a
we
vote.
can move on.
Okay.
Thank you.
Anyone have? Do we have? We do have to vote.
Yes, the board is going. There's going to need to be a motion for either. You can make a motion to uphold the denial or to reverse the denial and grant the license. And
Why would
then-
we have to vote to?
This is an appeal, and so
Okay.
yeah.
Gotcha.
So there needs to be a vote either to uphold the denial or to reverse the denial. Well, not reverse it, but instead to grant the license, and then the board will need to do a roll call vote.
Is there anyone on this board that will make a motion to uphold the denial?
I'll make the motion that we uphold the denial.
And I'll second that.
Any further discussion?
I have a question maybe for council. If this denial is upheld, is there a time frame in which Mr. Schuman could reapply, or is there anything he could do to remedy?
Usually like 3 years or something.
Yeah, I don't. He could reapply
Anytime.
And there's also Mr. Schuman may appeal this to the. I think it's Chancery Court here. They'll review.
Karen, would you take a roll call vote?
Cindy Bonner,
Aye.
Janet Booker Davis,
Aye.
Pamela Church,
Aye.
Stephen Eldridge,
Aye.
Larry Elmore,
Aye.
Greg Gilbert,
Aye.
Kevin Monroe,
Abstain.
Gay Moon,
Aye.
Todd Skelton,
Aye.
Trey Watkins,
Aye.
Judy Weatherby.
Let the record record that we voted to uphold the denial of the application. Mr. Schuman, thank you so much for coming down here. Clearly, it's a very difficult conversation to have.
Thank you for your time.
I think what we'll do, I'm showing it's just a little bit after 10 a.m. So let's go ahead and take at least a 10-minute break. So let's reconvene here at about 20 after 10, and we'll continue on with the rest of the meeting. Yeah. Stephen and Andy, do we have you back on the phone?
Yes. This is Stephen.
Okay, thanks, Stephen.
Yes, Andy.
All right, thank you, Andy. We'll go ahead and recommence. We're now to the point in the agenda where we have 2 reinstatement applications for potential action, and we'll take the first one listed, which is Kim Creasy, who has applied for reinstatement of a previously expired license. This case was discussed also yesterday in the committee meetings. Here, and the story behind this one is that upon expiration, a complaint had been opened. This is going back several years regarding non-payment of professional privilege tax. And as was discussed in the committee meetings yesterday, she has completed the reinstatement application. She has the option to show up and appear here, but she is not obligated to appear in person for this type of reinstatement. And I do not believe that she is here at this time. And it has been determined with respect to discussions, I guess, with the State Department of Revenue, that at this point she could not pay the professional privilege tax if she wanted to. It has been zeroed out effectively. They are not showing a balance in that respect. And then furthermore, going forward for the accountancy profession, unlike the legal profession, the professional privilege tax has been abrogated going forward, beginning next year. And so we have a reinstatement application that's been duly received, and I'll just turn it over to legal for any other comments or thoughts about process and procedure here.
Yeah, I think you about covered it. One thing I did want to note is that we have been in touch with Department of Revenue concerning her account, and we know that she's in good standing. So that's something. It doesn't mean that she paid it or didn't. I just don't think there was a record. Is that okay? Of what happened? It's just, she's in good standing, zero balance. So I think she was going to come today, but she's not here. I don't know if the board would like to discuss further. You have the option to reinstate, to deny, or maybe to open up a complaint referencing the old complaint.
I guess before we entertain a motion, is there any further discussion or comment on this case for reinstatement application? One question would be, we have received a valid reinstatement application. It appears to be complete. The CPE that needed to be done has been provided for. Is that correct?
Yes, that's correct.
Okay, so there's nothing open from staff's perspective on the reinstatement application that still needs to be done?
No, she's done everything that she needs to do at this point.
Okay. Mm-hmm. Any other questions or comments on this case?
Just to make clear, this is Stephen. We're just voting. We're not voting to either reinstate or not. We're voting to determine if the package is complete. Am I misinterpreting that?
Stephen, that was for the next person, Miss Tracy Wright. So now we're talking about Kim Creasy, so we do need a vote on the reinstatement.
Okay, so my question I had, and I asked yesterday, and I don't know that I was clear on my. When we typically have issues where people haven't paid their personal privilege tax, what has been the general penalty we've issued for that? Just being consistent, I guess, with the matrix and all that.
Stephen, give me a minute to see if it's on the discipline matrix. We have not been disciplining folks for this in the past few years because they simply have not been able to renew the license. So
okay, I mean, the issue I have is that we say that she's in good standing, which legally she is, but she's obviously missed 2 years of tax payments that other licensees who had to pay. I mean, just because they wrote it off, I think while it's true, it's also a little bit misleading as well. She wasn't in good standing, but because of a technicality, she can't pay it. That's my issue with this. I have no problem reinstating her. I just think that there needs to be some kind of repercussions.
Stephen, this is Maria. I just, as far as the legal department is concerned, we don't have really a record from revenue stating whether or not she paid. So I don't want to go on record saying that, she didn't or did not. She could have.
I thought they said that she was in good standing.
She's in good standing. That could mean that, I think the issue that came up is that they've since gone to like a different electronic system or something that kind of keeps record. And so I don't want to say they wrote it off or that she paid. I don't have knowledge of what exactly transpired. All I have knowledge of is that she's in good standing.
Okay, I think yesterday in the conversation it was mentioned by somebody that it had been written off, and even if she wanted to pay, she couldn't pay.
Stephen, I made that statement and was unable to find that in an email, so I'll retract that because I feel like that came up, but I could be wrong and we don't have that written anywhere, so I'll withdraw that.
And other than that, there's no outstanding discipline or no peer review issues?
No. Typically, applications, a reinstatement of an expired license is something we do at the staff level, but this one had a flag on it saying we were unable to resolve the prior complaint, and so that's why we're here, is just because of that complaint, and everything else is fine.
So, any further questions or discussion?
So have we exhausted any information we'll get from the Department of Revenue? Okay.
Kept sending emails, and he basically just said she's in good standing. But I asked for proof of payment, and they couldn't provide anything, and said, all I can say is that she's in good standing.
Well, if we can't get
confidentiality reasons,
yeah,
may not be able to provide much anyway.
What's the prior complaint you're talking about?
This one, the complaint based on failure to pay professional privilege tax.
Okay.
I'll make a motion that we reinstate the license.
Okay, we have a motion from Trey to reinstate the license for Kim Creasy. Is there a second?
I'll second.
Seconded by Larry. Is there any further discussion or comment or question?
Do we need to send any kind of letter of warning or whatever you do, or does that matter? Are we just taking the facts as they're presented to us rather than? I guess I was skewed in that comment from yesterday, so I'm trying to get out of that mindset.
You could send a letter of warning. However, with the fact that professional privilege tax is being done away with at this point, I'm not sure how much that would carry.
That's fine. I'm okay with that.
Okay. Any further comment or question? Let's go ahead and call the question. And Karen, will you please call the roll on the motion to reinstate?
Bonner.
Aye.
Janet Booker Davis.
Aye.
Pamela Church.
Aye.
Stephen Eldridge.
Aye.
Larry Elmore.
Aye.
Greg Gilbert.
Aye.
Kevin Monroe.
Aye.
Gay Moon.
Aye.
Todd Skelton.
Aye.
Trey Watkins.
Aye.
Judy Weatherby.
Aye.
Thank you, Karen. The motion carries, and I guess staff will be notifying the respondent here that she has been reinstated and met that criteria. The next item that we have is also a reinstatement application, but this is the one where we have a situation where today all we're looking at is reviewing the reinstatement application and determining that is in good order or not. We are not making a decision at this meeting to reinstate because our processes require that it effectively occur over a 2-meeting period if it's to happen at all. And so for Tracy, I'll turn it over, Maria, to you maybe to provide a little background in terms of what we are looking at here.
Could I remind everyone, just for the record, that I will be recusing myself and abstaining from any vote on this one because of the firm I was with before I retired was the successor audit firm on one of her clients. So I have knowledge of some of the record here.
Thank you, Larry.
Okay, so this is the matter concerning Tracy Wright. You all have a memorandum in front of you that kind of goes into detail, but to summarize, Ms. Wright had a CPA license through 2001, and then it since expired. And then there was a firm permit through 2000. And on October 7th, 2019, she has applied for reinstatement. Revoked, not expired. Excuse me. And so today, according to the rules that govern this process, the board just needs to review her application and make sure that the application is complete. And then at the next board meeting in January 2020, Ms. Wright can appear, and then at that point we can flesh out any concerns or address Ms. Wright regarding her history with the board. And so I don't want to, well, staff has, ascertained that her application is complete, but we just want to make sure that you all are in agreement with that. And no roll call vote will be necessary on this today. So happy to.
I didn't understand your correction when Wendy said revoked. Could you state
sorry.
those facts one more
Yes,
time
so
at the beginning?
I stated that her license was expired, but it is in fact revoked.
As of?
I want to say 2001, but I need to double check that.
I'll go ahead and make the motion that we accept the application as presented, not approve it, but accept it.
I'll second that.
So just to clarify, I appreciate, Trey, your motion and Stephen, your second, but is there action required at this juncture on the part of the board if we believe that the application...
If you believe the application is...
I was going to say,
Yeah.
do we even have to vote on that? 'Cause
Nope, there's no vote required. I
think I have in the past asked for one, but I don't think it's necessary.
we have a valid application. So now you're going to bring that to us for approval.
If the board, unless the board chooses or decides otherwise, then I guess the protocol would be that following this meeting, staff would notify Ms. Wright that her application for reinstatement has been accepted, but it has not been approved, and that there would need to be an appearance at the January board meeting. And it is at that time that the board will determine whether or not, and it's within its realm of options to choose to reinstate or to not, and to continue in revoked status. Is that correct? Okay. So
I have a question for legal. I just want to be absolutely sure that we don't need a request from the board that she appear. I'm just not completely sure the rule says that she has to appear. So I don't want that to be a technicality that causes any issue.
I mean, we could require her to appear, right, as a condition of that approval?
Yes, but I want to see if that needs to be part of a motion or not.
Gotcha. Because I'd like to hear from her.
There was a requirement on July 13th that she must appear before the board in person at a future board meeting as a condition of a reapplication. Is that an old reapplication?
No, that was a requirement, and she appeared in front of the board in July of 15, which I believe she believes met that requirement, but I don't think the board did. And so that's why I just want to be clear with her that in order for you to consider her application, would you all consider it if she doesn't appear, or is it in your mind, is it mandatory that she be here?
I think she should appear. I would. I think we should make a motion. I'll make the motion that we require her to appear at the January meeting.
Okay, is there a second to that? And then we'll open it up for discussion.
I'll second that.
Okay, seconded by Trey and moved by Judy.
Do we have authority to require it, or do we just invoke our authority under the rule that we intend to question the applicant as? That's not to avail herself of that intent.
I think
Well, surely we can require her to come in as a condition of that approval, can we not?
Yeah, so the rule says the board may, but given the fact that she probably wants to have her license reinstated and to comply with the board's request, I imagine that she would appear in January. I mean, we can't make her come here, but we can deny the license if we don't have enough information or we're not satisfied with the information that we have on her complaint history. And
Still fuzzy about the timeline. So you said you think that it was revoked in 01. There's a statement that it was revoked in 07. And then, like I say, it said she had to appear, and that was part of the complaint in 13. And then you said she did appear in 15, but that's not here. I'm just fuzzy about the timeline, and maybe we don't have to know that now. I don't know.
I'm not sure we need to know that now, but from the timeline record, she was revoked in 2007 for failing to comply with a consent order. And she attempted to go through the reinstatement process in 2015. I believe when she appeared in July of 15, I'm not sure if this is in the record. I just was part of the meeting, but when she appeared at that meeting, I believe they determined that the application was not complete and she would need to complete the application and the items required and appear at the next meeting. We gave her some options to do that at a couple of meetings, January of 16 and then May of 16, and she did not appear at either of those meetings, and the board denied her reinstatement application at that time. And now she's requesting reinstatement again.
There was another complaint in 15 that was closed without discipline.
Right, in that May, we can go back and look at the record, but I think because she was in a revoked status.
This may not be part of the application from her. Maybe it's more what we need from the staff, but I would like a more thorough timeline of what happened when, because some of the things you're mentioning are not here.
Just for the record, I pulled up online. She's still listed as Tracy L. Wright, CPA, on the internet. So, I mean,
Yeah,
we
we're
just
not.
need to be
This
careful.
is not. We're
Yeah, I was
not.
gonna say, we
We're
need to
not
be-
doing this case
okay,
right now.
okay,
So
okay. All right, yeah.
For the chair, I guess I apologize for getting us out of order. There was a motion that was seconded, so I guess we need to withdraw or modify that.
That's a very good
Potentially.
point, Tom. So I
I
think
got us out.
I'll
Out
make
of
a
order.
motion to withdraw that
Okay.
motion.
I considered this discussion relevant to that because I don't know whether she needs to appear unless I know a timeline and where we are as far as, like I said, there was a statement that she had to appear, but I'm being told.
I feel like
fulfilled
her
that.
appearance
I
is
don't know.
necessary so that we can
I
ascertain the
think so, too.
facts. So that would be my only concern.
I think it appears that it is within the prerogative of the board to request her appearance prior to approving the reinstatement application. The next time she could appear would be in January.
Yes.
And that would be how to proceed. So I think then, given the withdrawal of your original motion, and thank you, Todd, for clarifying that, we have the motion on the floor, I think, by Judy to require basically her to appear in order as a precedent to reinstating her license. And we had a second for that. Is there any further discussion on that requirement that we are imposing?
I would make a motion to amend that to request her appearance.
Okay.
And I think it clears this thing practically.
Okay, we have an amendment to the motion to substitute request for require. Is there a second to the amendment? We have a second to that. Any further comment? We'll vote on the amendment first and then the amended motion. Karen, will you call the roll on that amendment?
Honor,
Aye.
Janet Booker Davis,
Aye.
Pamela Church,
Aye.
Stephen Eldridge,
Aye.
Larry I'm
Abstain.
sorry, you're abstained. Greg Gilbert,
Aye.
Kevin Monroe,
Aye.
Gay Moon,
Aye.
Todd Skelton,
Aye.
Trey Watkins,
Aye.
Judy Weatherby,
Aye.
Thank you. So that amendment has been approved, and we'll now vote on the main motion, which is as amended to request her appearance at the January meeting or subsequent meeting prior to consideration of reinstatement for her license. I guess that motion's already been on the table effectively because of the amendment. So I guess we're prepared to vote on the underlying motion. Any further comments or questions? Call the roll on the main motion.
Cindy Bonner,
Aye.
Janet Booker Davis,
Aye.
Pamela Church,
Aye.
Stephen Eldridge,
Aye.
Greg Gilbert,
Aye.
Kevin Monroe,
Aye.
Gay Moon,
Aye.
Todd Skelton,
Aye.
Trey Watkins,
Aye.
Judy Mosley.
Aye.
Thank you. That motion carries.
And for the record, Larry abstained.
I think next on the agenda are the Naspa updates. And first up is from a Naspa Board of Directors standpoint, we'll turn things over to Andy Bonner, our representative here for our region on NASBA. And before I do that, Andy, just want to commend you for the regional call that you had convened earlier in the quarter for the executive directors and chairpersons of boards in the Southeast region. That was very informative and appreciated that very much. And I'll turn it over to you, Andy.
Thank you, Kevin. Just to let everybody know that all the committee appointments have been mailed out. So if we have any board members that have been assigned to committees, that they probably have received a letter now. I will be on the board for NASPA again this year, and also on the member relations with member boards, and will continue that spot for my second year. And also this year I will flip over and become chairman of the Legislative Support Committee, which will be an exciting area to kind of practice in. We're about to have our board meeting today. Today and tomorrow as we meet in Boston, and that's the reason I'm not present there today. A lot of exciting stuff that's on the agenda, and also for our annual meeting, which representatives from our board will be there on Sunday, Monday, Tuesday, and Wednesday. Obviously, the glowing question right now, and the thing that's getting the most attention with not only NASPA, but with all the state boards of accountancies and all 55 jurisdictions, is the CPA evolution. We have seen some input from some of the Southeast region executive directors that are concerned about a couple of things that are kind of circulating around. I know that Bill Reed gave a report to the Aicpa Council at the end of last week, first of this week, and he is going to be present here in Boston with Lori Tisch, who is also the co-chair of the CPA Evolution Committee, and then she's going to speak privately to us as the member relations boards this afternoon. And then she's going to speak to the board tomorrow to prepare us for the presentation that her and Bill will be giving on Monday morning. From that presentation, then we will all break out on Tuesday morning and kind of convene and talk about, we've already been issued the guiding principles, and really now it's like, where do we go from here? Because if you think about it, if changes are going to be made to this evolution project, then you're probably going to have a situation where, not only do we have to change the curriculum in colleges to prepare people to sit for this CPA examination, that we have to change the CPA exam itself. The focus that committee came back with was kind of focusing on the core that includes accounting, auditing, tax, and technology. And so they want to focus on that, and then really start to align education to go along with that. So you're going to see in this next year a large changes with education, large changes with the CPA exam being proposed, and you're already starting to see a lot of changes on the auditing side, and you'll continue to see a lot of changes in that area to kind of take the professional of what's going on in the industry and to have the education to support the audit quality that's expected in the public. And so really, as far as CPAs themselves, you're going to see a lot of reskilling, a lot of more education to adapt to these. And I think that probably, Kevin, you've seen that in your firm that you were a partner in. I'd say that a lot of other people at the table have seen that too. And so there's just really going to be a huge change in the way that we look at the profession. And there's going to be a lot of feedback because there's a lot of a lot of opinions about what the exam should be, and it seems like that, one of the things that is based on the letter that I got from the executive director, one of the things that we'll probably talk about a lot up here in Boston is that a statement that goes that one examination would serve all candidates with variations allowed within the exam sections that would correspond to area of study or interest, which, here again kind of sounds like it's really more than one exam. And so there'll be a lot of discussion about that. And that's all I have to report today.
Andy, may I ask a question? This is Pam. Hey, Andy.
Hey.
So when you say you anticipate changes in education, of course, I have a vested interest.
Yes, ma'am.
Have you gotten a feel for whether that will be accomplished through communications from Naspa directly to schools to inform them about how they should change in keeping with the exam? Or would it be more an indirect approach where boards would accept only certain courses? Has there been communication about that yet?
And there's just been, at this point, a lot of talk. I can see that NASPA has an education committee. So does the Aicpa. Those two committees have been talking and working together. I think there's going to be a lot of input, but it's going to be very quickly. Obviously, the thing here is timing. We can't wait 7 years to start changing the education. So, based on the meetings I have been involved in, there's going to be a reaching out to the education community, to the universities and colleges to say, hey, this is what we see. This is what are your thoughts on it? And people will be asked to give input and serve on the subcommittees to supply that input. And so my feeling, just based on sitting here and listening and reading the tea leaves, is that a lot of people are going to be involved. A lot of questions are going to be asked. We're going to get consensus from practicing and educators and Aicpa and NASPA and state boards, and they're going to try to do this thing right. Of course, being as big as we are, you're never going to have 100% agreement. But I know the education committee has been sitting there waiting for this day to say, okay, let's now that we have the guiding principles, now we're getting into the detail, and then from the detail, then we're going to be ready to jump on this and decide what needs to be added to the curriculum. So yes, a lot of input from educators.
Andy, this is Larry. Hope you're eating well up there. I'm sure you are. One question. You said a while ago, you made a reference to the fact that the verbiage on something you were reading indicated possibility of more than one exam. I thought we had moved on from that. I thought that was. Go ahead.
Yeah, we have definitely moved. It's going to be one exam. The problem I guess you'd say that the noise factor that's going on right now is that is something that was kind of put out there from one of the executive directors that said that he had a real concern with the variations within the exam sections that correspond to areas of study and interest. And that's specifically labeled in one of the leadership concepts of the guiding principles that we're going to talk about coming up in Boston. So there's definitely one exam period. The question now is that, okay, let's say that I have an interest just on tax, but I'm getting a CPA. I can actually go to the exam. The way I'm reading this, because I have no knowledge of this yet, the way I'm reading this is that I can go to the exam and say, I really don't want to talk about the IT or the audit in depth. I want to go in depth on tax, but then there's certain things I need to know about the other two that maybe are just logical, scratch the surface questions so I can focus my exam. Well, we used to have to take, as you know, Larry, we used to take parts that were pretty involved in all areas. I could focus on one area very deeply and then just scratch the surface on the others. Now, that's the way it's being implied in this letter that I received, or this correspondence. But, you know, as I said, it's very much going to be talked about in Boston, and I'm sure that we'll have a follow-up statement on that to explain that.
What do you mean you could choose to focus on? You mean as part of your taking of the exam, you would be graded more heavily on one area than the other or something?
Test would be different.
I thought you said there was one exam.
It's like one exam, but within that exam, it says here, and all I can do is quote you because I don't understand fully. Just sitting here reading the tea leaves, it sounds like you can take a variation and allow certain sections. Let's say that, you know, it says here with variations allowed.
Which means there's a different test, the way I hear that, and I'm very much against that.
Yeah,
However they do that.
Yeah, and I would say that a lot of boards that I have talked to, given my seat, have expressed the same opinion.
Yeah,
and that's what we're going to find out.
Yeah, I thought we had moved on from that, but maybe we haven't.
Anybody that gets the designation of CPA, regardless of which area they choose to follow, does not preclude them from operating in a different area later on. And if they haven't been tested accordingly, I mean, that's a problem. That's a real problem. So I hope that's not coming up. That would be my message.
We're going to find out the definition of that at this meeting. And I'm sure if that's exactly what we have interpreted that to mean, I would say a lot of people are going to have a problem with that.
Okay.
Any other comments or questions for Andy while he's up doing great work on our behalf at the NASPA committee meetings?
Do no harm, Andy.
Okay. Thank you.
Andy, thank you for that report and also for spending the time and effort to participate in terms of the leadership role that you have for NASPA. And we also have a number of our other members who are serving on various NASPA committees, and I'll open things up for any reporting on that. Larry, any follow-up on the committee that you're serving on?
Yes, the audit committee is done for this year. We just wrapped up the review of the audit report from LBMC back at the end of September and through early October, and that report will be presented at the annual meeting. This is a very active committee. Judy just told me that she's also been appointed to that committee for the 2020 year, so she and I will both be serving on that committee next year. But we have concluded our work for 2019, and we'll be going over the report at one of the sessions in Boston.
Okay. Thank you, Larry. And Judy?
I was on the Finance and Administration Committee and just received a letter that I'll be on the Audit Committee. I figured they bumped Larry off or something. So, but no, we'll be on there together.
I was surprised I got reappointed because they encourage you to go to another committee after 2 years, but this will be my third year. So
you must have been indispensable.
I either flew under the radar or something. I don't know.
Yeah. And just to Andy, be sure and see if there's a Torture chocolate there in Boston while you're there. I think they have one.
I will. I'll go check it out. That was some great stuff.
Okay. Thank you, Judy. And also thank you for your service on previously on Finance and Administration and now on the Audit Committee.
I'm making the rounds because I was also on the Ethics Committee before that.
Okay.
So.
And then, Janet, I think you've also got some committee service here.
I do. I'm on the Examination Review Board, and we finished our work for 2018 and did a report at both regional meetings, the Eastern and the Western, in June. And so now we're starting to plan for this year, 2019. And so we'll be meeting in November. to approve the current year plan and then get in the field work, and it'll be starting up again.
Okay.
But it's been good. Yeah.
Well, thank you for serving on that, Janet. And then any
Lot of
other
work.
committee
Kevin, I'm
members,
on the
Pam?
CBT administration.
Okay.
So just the administration of the test. We haven't had a meeting lately, but I did receive a letter that I'll be on it again next year.
Fiscal year 20, that's great. Thank you, Pam. Any other committee service report outs? First of all, just thanks everybody for serving. And it just is indicative of the health and interest on the part of the board here in Tennessee, which is just awesome. I think we're ready now for board committee reports. We've already had the enforcement report, so that's done, and we'll just go in the remaining order, and that begins with licensing, and I'll turn it over to you, Gay.
Okay. The first item that we had was an extension request, exam extension request for one testing window for an audit by Mr. Krell. The licensing committee voted to recommend to the board approval of his extension of one testing period for the audit section as a result of misinformation provided to him by Naspa on the expiration of his audit. They said it was 7/31 and it was really September 30. He sped up, sitting for FAR, did not pass it, and felt like if he'd known the true expiration date, he would have had more time to study and pass. So that was our recommendation.
Okay.
I'll second that motion.
Okay. Any further comment or discussion on that recommended testing window extension? We'll go ahead and call the roll on that, Karen.
Bonner,
Aye.
Janet Booker Davis,
Aye.
Pamela Church,
Aye.
Stephen Eldridge,
Aye.
Larry Elmore,
Aye.
Greg Gilbert,
Aye.
Kevin Monroe,
Aye.
Gay Moon,
Aye.
Todd Skelton,
Aye.
Trey Watkins,
Aye.
Judy Weatherby,
Aye.
Okay, any other items from the licensing committee standpoint?
Yes. Wendy presented an overview of the 2019 state-specific ethics course, identifying that the Tennessee Society of CPAs is following the Memorandum of Understanding, the available formats for the course. She also identified the additional approved sponsors providing this course, and then a small amount of feedback from participants on those additional sponsors. The next item was a vote to approve the Tennessee State-Specific Ethics 2020 outline, highlighting a couple of changes that our staff have recommended, being one that the CPE reporting requirement is going to be added to having to list the specific courses when we renew our licensing. Also, the new rules that have been added, meaning the CPE rules, classification and alignment with NASPA, Nano CPE was also approved, and then the continuous testing, which will be finalized about 90 days. Is that right? Okay. So that will be added to the outline. Also, under the rules of professional conduct, they want incorporated the conflicts of interest with some examples of those. And then the last item was part of the complaint process was to make sure that our licensees are aware that they do have a legal obligation to respond to notices that are issued from the state board. It was brought up that we wanted a little more information about reporting changes to the board, and Wendy pulled up our rule, and I believe we're covered. The rule is pretty specific about changes that any conviction by a court of competent jurisdiction of a felony or the limitation, suspension, or revocation of the right to practice public accountancy by any state board of accountancy or any other state, federal, or international agency. So those are all pretty clear in our rules as they stand. So the licensing committee voted to recommend that the board approve this outline. So then the Tennessee Society will take this outline and apply it to this Tennessee specific ethics course.
Okay, is that in the form of a motion recommending
Yes,
approval?
it is.
Is there a
Second.
second? We have a second from Judy. Is there any further comment or discussion? Karen, will you please call the roll?
Andy Bonner,
Aye.
Janet Booker Davis,
Aye.
Pamela Church,
Aye.
Stephen Eldridge,
Aye.
Larry Elmore,
Aye.
Greg Gilbert,
Aye.
Kevin Monroe,
Aye.
Gay Moon,
Aye.
Todd Skelton,
Aye.
Trey Watkins,
Aye.
Judy Weatherby.
Aye.
Motion passes. And Gay, any other items from a licensing committee report out?
We had an overview on some applications for reinstatement and application for license. Those have been addressed earlier in our board meeting this morning, so that is all from licensing.
Okay, thank you, Gay. We've already addressed enforcement, and so I think next up is Laws and Rules Committee, and I'll turn that over to Chairperson Janet Booker Davis.
We had an information update related to the continuous testing rule, which Maria talked about, and we were all present yesterday and heard that information. And Maria also updated us on the standing of some other rules that are making their way through the process. But did you have anything further to say today, Maria?
No, I covered it all yesterday.
Okay. And that was all that we had for
Okay.
this time.
Thanks, Janet. So no current action required on any matters by the board.
No.
Then the last committee is the executive committee, and yesterday that committee met in session, and we reviewed with Executive Director Wendy Garvin's help the status of the closeout of fiscal year 19, which is now in the history books, the year-to-date operations for fiscal year 20 year-to-date. No action is required on those items. Those are informational. We also reviewed the travel expenditures for the quarter, and there were no further or open items with respect to that. The one action item we have stemming from the executive committee is the review and need to approve the fiscal year 21 operating budget proposal for the board. And so in our committee meeting yesterday, Wendy highlighted some of the items that are going on. It's currently budgeted just at about a $9,000 deficit, but that is less than 1% or thereabouts of the operating expenditures that are proposed. And also those do not take into account any complaint revenue that may or may not be received during that fiscal year 21 period. Wendy, any other highlights for the fiscal year 21 budget that you'd like to reiterate?
I think the only thing I'd like to reiterate is we talked a lot about the fact that we may see some savings with regard to rent and copier usage and shredding services as a result of our alternative work solutions. And we are starting to see some savings on rent. However, our IT costs have gone up, and so which is really diminishing the savings that we were seeing in rent. So we've kept that state professional services. I'm proposing a budget at $62,000, which is higher than the budget for the current year. So that's probably the biggest notable difference.
Any other questions or comments for Wendy on the proposed budget for fiscal year 21? Now I'll entertain a motion to approve that budget. Moved, and is there a second? Second. Seconded by Greg. Thank you. Any further comment or discussion on the budget approval? Karen, will you please call the roll?
Andy Bonner,
Aye.
Janet Booker Davis,
Aye.
Pamela Church,
Aye.
Stephen Eldridge,
Aye.
Larry Elmore,
Aye.
Greg Gilbert,
Aye.
Kevin Monroe,
Aye.
Gay Moon,
Aye.
Todd Skelton,
Aye.
Trey Watkins,
Aye.
Judy Weatherby.
Okay, thank you. The motion carries and is approved. The next item on the agenda is the legislative update. Maria, any further discussion or update there?
No, not at this time. Thanks, Kevin.
Okay. And then the next item, any old business to come before the board?
Question.
Yes.
Hopefully, it's old because it was earlier today. In the consent agreement, this goes back to the review for Mr. Application. He is prohibited from, will not make or permit to be made any public statement to the effect that defendant does not admit the allegations of the complaint or that this consent contains no admission to allegations, without also stating defendant does not deny the allegations. A couple times where pretty thin ice. I don't know how the SEC enforces these and what their thresholds are, but I can't help but wonder if it's worth potentially referring the recording of this meeting to the enforcement, whatever they want to do with it. But I don't want the board to be in a position of having entertained a brief. Throwing it out there for discussion and consideration. It's an escalation.
Look, I hear what you're saying, but one thing, I don't want to forward something along. I think we're stirring a pot.
It's fair.
I don't want to cause him any ill will from this meeting beyond the fact that we've just rejected his license. This is my opinion; it's not legal for sure. But I feel like if we were to do that, we could be opening up another can of worms for this man. I don't want to. I do not want to be a party to that, if that's at all possible. It's a public meeting.
Yeah.
Somebody wants to go get it and do what they want with it, then so be it. But I certainly don't want us to hand deliver it to the SEC.
Any other comments or thoughts on that matter?
Not making a formal motion then if there's not consensus there with the board.
I hear what you're saying. I don't want to get this guy in any further trouble.
Yeah, counsel might have been helpful for him today.
Yeah, I agree.
Any further old business?
I'd like to bring up one thing that I failed to put in the director's report or elsewhere. I had sent you all an email a month or so ago regarding internally our discussion about requesting peer review documents at firm renewal to help assist us in showing compliance with peer review. So maybe we don't have some of these issues that we had in the legal report. I really only received one concerning comment back. So our plan is to move forward with not requesting the report, but we are going to request the acceptance letter to show that they've had a peer review and completed that process. If they have not, then we'll inquire with the firm to see if we can get some more information before approving that firm renewal. So does anyone have anything they would like to add that they were unable to provide me at an earlier time?
I don't remember if I responded to you or not.
I don't recall that I got a response.
But I do think it's a good idea.
Okay.
Wendy and I've had some of these one-off conversations of just, in general, how there's certain things, like if you're a broker-dealer, for example, you audit broker-dealers, right? You've got to be PCOB, you got to do certain things, whatever. But retirement plans and things like that, she and I have had a conversation because there's people that do one retirement plan. And, of course, every organization that oversees these type of entities does not like firms that do one retirement plan or does one broker-dealer, right? They're trying to – the thing I always worry about, and when I'm looking at this, there's all kinds of data out there on the retirement plans. We have a big retirement plan practice, and I wonder that the people that get and have the one retirement plan, are they truly supplying that to the peer reviewer and saying, I'm doing this work? And to Wendy's comment, when we've talked previously about this, is, well, without the peer review report, we don't know. We can tell you whether or not they've gone through peer review, but we couldn't tell you whether or not that area has been covered as part of that peer review. And so I do think that's valuable. I think it's good to know that people that are going through the peer review process are actually getting peer reviewed on the areas in which they operate. And so the report will lead us into some of those required selection areas, at least. That's a piece there. So I think it's good.
So just to be clear, Trey, I did propose collecting the report and the acceptance letter. I backed off of the report and was just going, because I had a concern from a board member about collecting the results, and concern that
Didn't
we were then using those results, I think, from a disciplinary standpoint.
But as long as they pass, or even pass with deficiencies, what would we even do with that?
We aren't currently, based on prior conversations this board has had, we are not opening complaints simply based on the results of a peer review. If you are eventually terminated for having successive failed reports, then we have open complaints. But based on one that comes through, we would not. I have not been at the discretion at the decision.
I would encourage you to collect the reports. That would be my vote.
Okay.
I don't know how the rest of the board feels about that, but I think it's important enough to our profession to have that information under our purview. And we have, just so everybody knows, we have been written up because of our oversight responsibilities over peer review in the past by a state agency or whoever it was that came in and reviewed our systems. And part of this process, I feel like, is us getting some control back over that process.
Now, another piece of clarification is that we did have some rule changes last year that required firms to submit their documents, but that is happening kind of behind the scenes in what we call FSBA for short, but it's a portal that state board staff has access to. The problem with that portal is it doesn't talk to our licensing system, so there's no way to assess compliance at renewal. In addition, we only have documents for firms that have scheduled a review after June 1st of 18. So it's going to be a few more years before we can get that database to have all the documents that we're looking for. So that is the reason I'm asking to, or planning to do this now. Does that help, or does that cause any more concern or questions?
Well, here's my problem. My problem is I do government work, so I do contracts with the state of Tennessee. As a result of that, my peer review report is out there, whereas other firms are not because they don't operate in that area. So mine's public information and others are not. So I don't think it's a bad idea. No, I'm not saying it's public per se coming to the board. That's not what I'm implying here. Right. But I'm just saying we have a system whereby certain firms have it out there and certain firms don't. And so I think it's important that our board have the ability to see the results of those peer reviews.
In the past, we had assessed compliance with enrollment. If you were enrolled, then you were complying. But as we saw in the legal report, we have a couple of firms that had been kind of skirting that process, and we kind of have to find them by chance. And this would help us better. Karen will see every single one, and it won't get approved unless there's a completion letter and or report provided.
If it's submitted with their application, permit application, does that make it public?
No. So, and so legal has reviewed that, and they believe the statute keeps that information confidential, even though it's part of a license application.
Okay.
So meaning for everyone else who is, if somebody requests the full file on firm A, we would exclude the peer review documents in that public records request based on statute.
So there wouldn't be any disclosure of any particular companies that were reviewed as part of that process?
No, because we would just be asking for the report and or acceptance letter, which does not indicate any client information.
Given the timing of where we're at in the firm renewal process, if we wanted to, in addition to requesting the acceptance letter, if we wanted to request an underlying report, are we operating within a time frame where we could do that, given where we're already at in the cycle?
I'm going to ask Karen's thoughts. Yeah. Okay. She believes we can add that relatively quickly. So we already have the base application created from the IT group, so it would be adding a piece to that, which is easier than creating it.
Given that you'd said earlier in response to Gay's question that the underlying peer review report would still appropriately not be made public in a public records request.
Correct.
Kay, does that address any concerns that you have about collection, or are there any other concerns about requesting the underlying report?
I think am I the one that sent the concern? I just,
Yeah.
no, I mean, I'm fully for it. I have no problem with it because I think it would help in our enforcement. My concern was that we were requesting something which we'd never requested before, and now all of a sudden that was going to be opening up a lot of complaints. But if okay, and then my other concern was we sold practitioners on it because it was not going to be available to the public under the Freedom of Information Act or something like that. So if we're covered in both of those areas, I think it's great to help us protect the public.
Okay, so any other comments or agreements or disagreements on that sentiment? It sounds like there's at least a consensus to recommend that you go ahead and request the underlying peer review report in addition to the acceptance form, given that it's practicable here and it doesn't violate the open records, need to preserve the confidentiality of the peer review report.
Do we need a motion to do anything on that? Or?
So here, I didn't need board approval for this. It's laid out in law and rule, but I hated to make that kind of change without getting some input from you all. So no, I don't think it's necessary. Unless you think otherwise. Okay.
All right.
Do we need to make a motion just to support the fact that we agree with it? Since
Sure.
this is such a drastic change?
I mean, that would be great for me. It helps me with anyone who asks, I suppose.
You can say the board voted on it.
So we can certainly do that. Sounds like there's no objection to going ahead and proceeding on that basis. So
I'll make the motion that we start requiring the submission of the peer review reports with renewals
And I'll
And
second.
acceptance letter.
and acceptance letter.
And I'll second.
we have a motion by Trey and a second by Judy. Is there any other comment or discussion? If not, Karen, will you please call the roll?
Andy Bonner,
Aye.
Janet Booker Davis,
Aye.
Pamela Church,
Aye.
Stephen Eldridge,
Aye.
Larry Elmore,
Aye.
Greg Gilbert,
Aye.
Kevin Monroe,
Aye.
Gay Moon,
Aye.
Todd Skelton,
Aye.
Trey Watkins,
Aye.
Judy Weatherby,
Aye.
Thank you, Karen. That motion passes. And thank you for bringing that up to our attention so we could specifically kind of comment on that. Is there any remaining new business before the board? If not, I think we'll adjourn the meeting and just thank everybody for making the trip in for those that are traveling, and also thank staff for working so hard to prepare for the meetings here this quarter. We are adjourned.
Appreciate it,
See you
guys.
guys.
Thank you.
Thank
See
you.
ya.
Bye, guys.